All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Please be seated.
Good afternoon and welcome to the North Carolina Court of Appeals. I'm Judge Toby Hampson. To my right is Judge April Wood. To my left is Judge Michael Stadding. So we have one case on the calendar for argument today, in re Goldberg. Following the conclusion of that argument, we will recess for about 5 minutes, and then we'll come back into ceremonial session to hear a motion for admission of a new attorney. I think that pretty much covers it. Thank you to Marshal Ricky Parks, our Supreme Court Marshal, standing in today, and to Roderick McFarland, our clerk for the day. If there's no further business before the court, we'll hear from the appellant and in re Goldberg.
May it please the court. My name is Paul Dubling. I represent the appellant, Mr. Goldberg, in this case. With the court's permission, I'd like to reserve 5 minutes for rebuttal. This case is a little remarkable in what's not disputed. It was a very short hearing. The transcript is easily reviewed. This petition for deregistration from the North Carolina Sex Offender Registry was dismissed by the trial court for lack of venue. This case took place in Mecklenburg County, and my understanding from the briefs is that the state doesn't dispute that venue would be appropriate in Mecklenburg County. The state argues primarily that the trial court lacked jurisdiction over the case. Our position is quite simple, really. The structure of the deregistration statute, 14-208.12a, specifies that a person required to register may petition. It doesn't set limits on who may register. It doesn't say they may register if they reside in the state or if they were convicted in the state. The statute says that all people may register. Second, it's rare that this is true. There are a very limited set of privileges and immunities of residents of the United States of America, but access to the courts are one. The state's position is that a person who resides in North Carolina and is on the North Carolina registry may petition under 14-208.12a for deregistration. The state's position is that a person who does not reside in North Carolina, but who was originally convicted of the qualifying offense that led to their original registration may petition in North Carolina courts for deregistration under 14-208.12a.
Is part of the confusion here that the statute doesn't quite address expressly this situation where you have somebody that does not reside, right, in North Carolina in a particular county moving for deregistration? It says file it where the party resides.
Yes, Your Honor, the statute is clear. If we take those three instances, convicted in North Carolina and resides here, statute covers that. Convicted in North Carolina doesn't reside here, statute covers that. Not convicted in North Carolina, doesn't reside here, but is registered because at some point in the past they moved to and then left North Carolina, statute doesn't cover that. I would submit to the court that there must be jurisdiction. Otherwise, it's a violation of the Privileges and Immunities Clause. There must be jurisdiction somewhere. The jurisdiction of the North Carolina courts applies to all justiciable controversies. I think what happened here, and I offer this to the court as an alternative, really, is that if you look at statute 14-28.7, it actually says, this is people who are required to register. It says a person who is a state resident and who has a reportable conviction shall be required to maintain registration with the sheriff of the county where the person resides. And so I believe under the original and authorizing statute, only a person who has a reportable conviction and is a resident of the state of North Carolina is really required to register at all. And then you track the language of, it says maintain registration, but that phrase is used throughout. Maintain registration is the phrase used throughout the statutes to indicate a duty to register. What has happened as a matter of practice, though, is when people who are on the registry leave the state of North Carolina, they simply cease communicating with the sheriff, but they stay on the registry as maintained by the Department of Public Safety. Now, that's not a de minimis problem, because the fact of being on that registry leads to loss of certain rights and guarantees at the federal level. So it's not the case that because you're simply on the statewide DPS registry, nothing bad is happening to you. Your passport must be marked, et cetera, et cetera. There are consequences to that. But when you actually read the statute as a whole, I believe the understanding of the legislature was, like many other states, if you're not a resident of North Carolina, why would North Carolina maintain you on the registry? You have a duty to notify the sheriff when you're leaving. If you came back, you would, of course, have to re-register per the statute.
But if your time hasn't expired to be on the registry, there's really no mechanism to remove you from the registry if you move from the state of North Carolina, is there?
Well, what would happen is all of the registry information is collected by the sheriffs and then simply forwarded to the Department of Public Safety. The Department of Public Safety is just a repository. So conceivably, and I think sort of practically, what really should happen is when someone is no longer required to maintain registration with the sheriff, that information would get forwarded to the Department of Public Safety, who would then say, okay, this is not a person registered. The Department of Public Safety under the statute doesn't have independent duties regarding maintaining registration. All of that information comes from local sheriffs, and local sheriffs are the only law enforcement agency that registrants actually interact with. That's to whom they fulfill all of their registration obligations. So the language, a person who moves out of state is no longer required to maintain registration with the sheriff. I believe the statute actually contemplates that that would be reported to the Department of Public Safety, and that person would no longer be on the registry.
But that's not what happens, is it?
As a practical matter, no. What happens is that persons are simply on the registry, and if you go on the state website, it would just say out-of-state address or something like that. But to me, that explains why there's this hole in the registry statute, because the legislature didn't contemplate this situation, because the registry statute isn't actually set up as if this were going to be a problem. And that's really sort of it. My read of the statute, and I would argue to this court it's fairly plain, is that if you're asking what was the legislature thinking, the legislature was thinking that people who don't reside in North Carolina wouldn't be registered. So when they contemplated formal deregistration proceedings, they only thought about where would someone apply to deregister based on either their conviction or where they live. And the state's brief, I think, is probably right about this point, that the legislator thought, okay, if the person was convicted in North Carolina, then the jurisdiction in which they were convicted is likely to be the most readily able to respond and answer the questions required for deregistration. If the person wasn't convicted in North Carolina, well, clearly someone has to have access to the court, and there the most viable venue would be where they live. But there's this hole in the statute, and that hole, I believe, is created by the legislature simply not contemplating that someone who was neither convicted in North Carolina nor resides in North Carolina would be filing a petition for deregistration because such a person is no longer required to maintain registration. If the court, this court, weren't inclined to follow that logic, then I point to the text of the statute and why these should be read as venue provisions, not jurisdictional provisions. And that's because the text is very clear. A person required to register under this part, and this part is part one of the registration proceedings applying to people who have not been adjudicated sexually violent predators or who are not juveniles, the normal sort of sex offender registration. A person, Mr. Goldberg, is clearly a person required to register. He is registered. Second, and as I note in my brief, and most importantly, if you don't, not you, of course, but if you don't as a legislature provide access to the North Carolina courts on the basis that this individual doesn't live in the state, that is actually an absolutely clear violation of the Privileges and Immunities Clause. So when you take the language of the statute, which on its face applies to any person required to register, and you consider the basic canon of statutory construction, that you want to read the statute so that it doesn't create a clear constitutional violation. I mean, we assume the legislature did not sort of say, okay, forget those guys, we don't care that they have a constitutional right to this. When you put those two things together, it makes much, much more sense to read the statute as a venue provision if you are not inclined to look at the statute as a whole and say, wait a second, this guy shouldn't be registered anyway on the facts of this case. And that's really it, Your Honor. I'm certainly happy to answer any questions, but in some sense, my argument is neither lengthy nor particularly complex.
Well, as I understand, the registries are state-specific, correct?
Yes, Your Honor.
Your client was convicted in federal court in South Carolina.
Yes, Your
Then he
Honor.
moved to North Carolina, registered here like he was supposed to, then moved to Florida, registered there like he was supposed to. And as I understand, he's also already been removed from the registry in South Carolina,
Yes, Your Honor. He petitioned for deregistration in South Carolina and was removed. And
where the
then,
conviction occurred.
yes,
So I'm intrigued by the trial judge's comment that, of course, the full faith and credit clause should apply. If he's, if he lives in Florida, why didn't he petition down there? But the reality is, it's because they're state-specific. Isn't that right?
that is my understanding, Your Honor. As Mr. Goldberg's advocate, I would be perfectly happy if this court were to rule that the trial court should have simply accepted South Carolina's determination. But in candor to the court, I don't think the trial court's assertion was legally accurate. These are state-specific. What South Carolina chooses to do about the fact of Mr. Goldberg's conviction and what North Carolina chooses to do about the fact of Mr. Goldberg's conviction are simply unconnected. South Carolina has a distinct registration scheme, distinct tiers, distinct criteria, distinct lengths of time, a distinct process for removal. North Carolina has its same. I am frankly and regrettably unaware of any circumstance where deregistration in one state has some sort of binding effect on another.
So one of the issues that intrigues me about this case is, we have this long line of case law now, well developed, that says these types of orders are actually civil in nature, right? You have to appeal them as a civil order, not as a criminal order. And here, this case sort of like is right at the intersection of that civil and criminal aspect of it. I noticed like the form that's filed for the deregistration is a criminal form. The trial court's order is entered on a criminal form. And, it strikes me, it's almost like if this were truly a civil order that was no longer, of any prospective effect or a civil judgment, it's almost like you'd file a Rule 60B motion, right? That would say, that there's no further, this order isn't enforceable prospectively since he's been removed in South Carolina and no longer lives in North Carolina. And, I don't know. I'm just kind of throwing this out here because it's interesting to me where we see this intersection of these civil orders in these criminal proceedings.
Yes, Your Honor. There actually there has been some change in that procedurally just in the last month or so. Pursuant to a lawsuit that, again, in candor, I was involved in, the AOC, the Administrative Office of the Courts, actually just changed the deregistration form to make clear that it is a civil form. And I understand that they are going to discontinue the practice of hearing deregistration petitions under the original criminal case number. What was happening is if there was no original North Carolina criminal case number, they were simply making a new criminal case, which then showed up on registrants' criminal histories as a misdemeanor offense. I pointed out that seemed improper, and the state, I believe effective March 7th, early March, actually changed the internal rules. If you look at the statute, there's nothing in the statute that specifies whether and how this would be heard other than in superior court. It doesn't say it's a criminal action. It doesn't say it's civil. The case law you refer to has long said that these are civil actions. There was a mismatch between that case law and the way they were actually handled as a matter of practice, but that practice has now been changed to accurately reflect that these are civil proceedings.
Thank you.
Again, Your Honor, I have an abundance of time. I'm happy to answer any questions, but at the end of the day, my argument is straightforward. Thank you.
Any further questions? No. You reserve the rest of your time for rebuttal. Thank you.
Yes, please.
May it please the court. My name is Joe Finarelli. I'm a Special Deputy Attorney General with the Attorney General's Office and here on behalf of the state. The trial court's result the state believes was correct. Its reasoning to get to that point, as we point out in our brief, was not correct. The jurisdiction versus venue question, although it was clearly raised by the state at the hearing, the petitioner argues in a reply brief that the only argument that the state made was one of venue. That is simply not true. The state did preserve that argument because the assistant district attorney said as follows: he no longer resides in Mecklenburg County, so it's the state's position that Your Honor doesn't have jurisdiction to hear this matter.
Mr. Fennerelli, let me ask you a question.
Yes.
Because I've had an opportunity to read your brief and the arguments. Mr. Goldberg is registered in the state of North Carolina because at the time that he moved to North Carolina, he was required to register, and he no longer resides in the state of North Carolina. He moved to Florida, presumably did it correct. He notified everyone like he was supposed to do, the sheriffs in the respective counties. And so he's now been removed off of the registry of the state in which he was originally convicted, and North Carolina's his holdup. So what court in North Carolina do you contend would have jurisdiction to hear Mr. Goldberg's petition? I mean, if there's no jurisdiction, then he's in legal limbo and he never gets off the registry, and that doesn't seem as though that would be constitutionally correct.
I don't have a good answer, Your Honor, because the legislature establishes which courts have jurisdiction, and the legislature, as Your Honors pointed out during the course of petitioner's argument, has not provided how this particular situation is supposed to be addressed.
Don't Superior Court judges have statewide jurisdiction? I mean, they even used to be elected statewide because they have statewide jurisdiction, don't they?
They do, and I think the stumbling block from our position is this court's decision in Ray Dunn suggests that a virtually identical provision in the same section of 14208.12a is a jurisdictional issue, not a venue one. Now, it's a very short opinion. It was a North Carolina resident convicted in North Carolina, filed the petition for removal in the county that was not the county of conviction. And this court said the trial court in the county where he filed did not have jurisdiction to consider the petition.
Isn't that because he was a North Carolina resident and the statute explicitly says he has to file in the jurisdiction in which he was convicted?
I agree that that's the reasoning from the court. The point being, though, it's not treating that as a venue issue. It's the same, I think the same principle would apply if you've got a North Carolina resident who files in the wrong county. It's not that this court said the Superior Court has jurisdiction, it's just the wrong venue. This should be remanded for transfer of venue to the proper county where that Mr. Dunn resided or where he was convicted. The court didn't say that. The court said it was a jurisdictional defect that it was filed in the wrong county. So extrapolating from that, understanding it's not a...
So Dunn, though, they vacated the trial court's order and dismissed his appeal, so presumably he can go to the county in which he was convicted and refile his petition.
Agreed.
So here, we've got Mr. Goldberg, which the state contends it's a jurisdictional issue. Where's he supposed to refile his petition?
I don't have an answer for you, Your Honor. And I think that's a gap in the legislation. Certainly, I think Mr. Dubling's argument that he raised at the beginning, that perhaps it was the legislature's understanding that there wouldn't need to be a petition for removal because of 14208.7, that the purpose of all of this is to protect North Carolina residents and North Carolina citizens. If you have an offender who is, while registered in North Carolina as required when in North Carolina, who then leaves the state, the public protection issues are less acute if you've got someone residing in Florida or Kentucky or wherever else.
So this the statute requiring registration is supposed to be non-punitive. It's to protect the public safety. But when an offender is on the registry, there are some punitive issues going on, right? I mean, his passport's got to be flagged, he can't do certain things, can't go in certain areas, because...
If in North Carolina, yes.
Right, so if he comes back to North Carolina, I mean, he's free to do whatever he wants to do, he's not on the registry in any other state, but if he comes back to North Carolina, then he is still subject to the registry, and there's no way for him to get off.
If he comes back to North Carolina in a residency capacity, an employment capacity, or an educational capacity, he's subject. That offender would be subject to the requirements. He would have to report to the sheriff of the county where he is now going to be living or working or attending school, and then all of the requirements associated with registration follow.
Well, I'm just talking if he's driving through,
He's not subject
through
to
the
those
state,
requirements.
he has a relative who is graduating from middle school, and he goes to the school to attend the graduation, what happens to him then? Because he's on the registry. It's a clear violation for him to go to the middle school to attend
Yes,
this graduation, right? Because he's on the
Sure.
registry.
If he were, yes, I think that's correct.
Even a non-resident would be subject to the registration requirements.
Yes, if he was arrested in North Carolina, this hypothetical offender were arrested in North Carolina for violating a registry provision, he would be subject to those requirements.
So how does the state contend he gets off the registry?
Well, I think if you're interpreting the way the panel in Ray Dunn did, that this is a jurisdictional, not a venue question. Let's assume that you're saying that. I think the only mechanism would be reestablishing residency in North Carolina and petitioning for removal in the county where you reside at that time that you file that petition. I don't know, the way the statute's drafted, there isn't another mechanism for doing so. You either need to be a resident of North Carolina, well, either way, you have to be a resident of North Carolina. This is certainly not the model drafting for covering all the contingencies, as the court has aptly pointed out.
Why shouldn't we read the statute where it says, in the district where the person resides, as simply meaning resides at the time of registration?
Certainly, the court can interpret the statute the way it sees fit. The only problem there is you're reading words into the statute that aren't there. I mean, that isn't what the legislature has written. It's where the person
Well, in the scope of
resides.
the statutory regime, though, not just this statute,
Well, and,
where is the person required to register? Yeah. In the county where they reside.
yes, they're required to register in the county where they reside. That our alternative argument in the brief, I think piggybacks on the petitioner's contention that Mecklenburg County, in this particular instance, would be the appropriate county. Unless you read, let me just say it this way, unless you interpret the statute to mean includes resides at the time they were registered or at the time they were last a resident of the state, okay, then we're narrowing the number of counties because it's going to be a particular county that can be the recipient of that petition and address it appropriately. The concern of it's any county because every county presumably has jurisdiction. If this is not a jurisdictional problem and this is a venue provision, a lack of definition would give an offender the ability to file the petition in any county that offender
But we deal
chose.
with that in civil cases all the time, right? We have this general proposition that venue is proper in any county in North Carolina. And yet,
Yes.
we also then we're able to appropriately apply other statutory provisions that provide for, venue where the plaintiff lives, venue where
Part of the,
defendant resides.
I'm sorry, part of the problem, Your Honor, though, is that intersection that you pointed out earlier in Mr. Dubling's argument between civil and criminal law is there really isn't a clean mechanism for transferring venue, despite the fact this is clearly a civil proceeding. That case law has been established. The venue statutes don't anticipate the filing of this petition. They talk about summonses and complaints. They talk about answers and times within which one has to transfer venue if venue is considered by the defendant to be improper. And there are standards in 1-76 through 1-87 or so is the venue provisions that govern which court or which county a trial must be conducted. Doesn't say anything about where it's got to be filed. I concede that, but it discusses where the action has to be tried. This kind of petition, it's not referenced as a specific action in any of the more specific venue statutes. The statute that governs motions to transfer venue contemplates the filing of a summons and complaint, a time in which you have to answer and demand in writing that venue is improper. That doesn't happen in these petitions. I think the record that Mr. Dubling has prepared and the supplemental record makes clear there's a petition, there's no response from the state, there's information that's gathered, it's set for a hearing, and then you have a hearing with an assistant district attorney and an offender and his or her counsel, and in front of a superior court judge. So if you are looking at this as a venue problem, and venue is proper somewhere, unless you're narrowly construing where that venue is and reading the statute in such a way that narrows that venue, I think you're creating problems for the administration of these petitions if and when they are filed in counties where there is no connection to the offender because it's not where they reside or it's not where they were last registered, and therefore there's records of their compliance with the registry. The argument that we raised with respect to jurisdiction was simply an awareness of the In re Dunn case. The alternative argument that we make in the brief that says if this court says that's not a jurisdictional issue, this is whether In re Dunn got it wrong or you're not bound by In re Dunn because it was interpreting a different provision of the statute where they're actually specifically addressed, a situation, whereas we're all in agreement, this statute does not address what is supposed to be done here.
If it is a jurisdictional issue, is it personal jurisdiction or is it subject matter jurisdiction? Is it a matter of the contacts the person has with the county specifically, or is it a superior court's authority to hear these at all?
I don't know, and I wish the court in re Dunn had explained what its basis for the jurisdictional argument. I think there is certainly, looking at the provision, there are aspects of it that make it look like a venue provision. I think that's an inescapable conclusion when you look at the language. It's talking about where it should be filed, not because earlier in the same subsection, it says that they can be filed in the superior court. So again, I feel somewhat boxed in because this court has said in one respect for a different circumstance, but the same subsection of the statute, it's a jurisdictional issue, not a venue one. If this court is either not bound by that conclusion or considers that it's a problem from a constitutional standpoint, the privileges and immunities issues that Mr. Dubling raised, or just says, we think it's a venue issue, and this has to be filed somewhere. So we're going to interpret the statute to provide some mechanism or some locale for this petition to be filed so that that registrants who are worthy and deserving of being removed from the registry can petition the court to do so. I mean, it's not that the state is taking the position that none of these people should be taken off of the registry forever and ever. It's the position that if you are saying that this is not jurisdictional, the county of last registration is the appropriate county. But that requires rewriting the statute in a way to address, or writing into it entirely, a provision that currently doesn't exist.
But even-
I'm sorry. Well, you did mention the Privileges and Immunities Clause, and Mr. Goldberg's counsel brought up that argument also before the trial court, that if the court says they don't have jurisdiction, then he couldn't file anywhere, then it's a clear constitutional violation. And then he also raised it in his brief, but I didn't really see a response from the state regarding that argument. So what is the state's position?
We did not take a position in the brief on whether this is a privileges and immunities problem. Looking at the case law that Mr. Dubling cited this morning, looking at it this morning, the case law that he cited, the two cases that are referenced in his brief are stating the general principles of what the Privileges and Immunities Clause is. I did note that both of those cases, the court upheld the statute that was being challenged and rejected the Privileges and Immunities Clause. We focused on the jurisdictional question simply because this court's decision in Ray Dunn was there and we felt it needed to be addressed in some way. But the state does not have a position on whether this is a privileges and immunities issue.
And in your brief, you do note that the court will interpret, whenever possible, a statute so as to avoid absurd consequences. So is the state's position there is no absurd consequence, or is the state's position that putting Mr. Goldberg in legal limbo where he really can't file anywhere might be an absurd consequence?
I don't think our position is either of those, I don't want to say extremes, is either one of those options. I understand the box that I'm in with you, Your Honor. If the court concludes that because this is a privileges and immunities issue, and aside from the citation of those two cases, there's no argument in petitioner's brief either. I mean, this is a clear violation of the Privileges and Immunities Clause. Here's two, century-old Supreme Court cases that talk about the standard, but none applying the standard to a statute like this, or even an example where the court upheld a challenge on a privileges and immunities issue. So if the court determines, if you as a panel determine that this is a privileges and immunities problem, if Mr. Goldberg and others like him are left in legal limbo, then your approach, I think, at that point would be crafting or interpreting the statute in a way that avoids that consequence. The suggestion in our alternative argument is, I think, the best that I can offer for how to go about doing that, but it's a problem with the way the statute was drafted, whether that was intentional from the legislature's standpoint or accidental thinking that it wouldn't be an issue because these folks would be removed from the registry once they were no longer within North Carolina's jurisdiction. I can't say, and I'm not sure there is an answer to that question. There's clearly a gap in the statute. It clearly does not address this particular scenario. And if the court were inclined to treat this as not a jurisdictional question, but a venue one, identifying that the county where an out-of-state registrant was last registered, such that there is a record of compliance by that registrant while under the registry in North Carolina, would be the appropriate way of threading that needle. Unless the court has other questions, I think I've exhausted the argument that I had hoped to make, and I'll leave the time to Mr. Duba.
Thank you. We'll hear from the appellant on rebuttal.
Thank you, Your Honors. It is frankly a little exciting as a lawyer. I never thought I'd get to actually cite appropriately the slaughterhouse cases in a brief that I did. But in answer to Mr. Frinarelli's note about the lack of a lengthy argument, the Supreme Court said in the slaughterhouse cases that the implied guarantees of the Constitution are to come to the seat of the government to assert any claim he may have upon that government, to transact any business he may have. He has the right of free access to its seaports, through which all operations of foreign commerce are conducted, to the sub-treasuries, land offices, and courts of justice in the several states. Frankly, there's not a more extensive argument in my brief because it's a foundational principle of American law that you can't exclude people from your courts based on the fact that they reside in another state. It's up there with the principle of judicial review. It's a given. Judge Hampson, I also wanted to note that you had asked about personal versus subject matter jurisdiction. Of course, in this case, it would only be subject matter jurisdiction because any personal jurisdiction issue would be waived by the petitioner voluntarily submitting themselves to the authority of the court, which allows us to look solely to the general jurisdiction of the Superior Court. We don't need to concern ourselves with issues of personal jurisdiction because in every case, any such issue would be waived. And the North Carolina legislature has, of course, conferred on the courts all authority to hear all justiciable actions. And clearly, this is a justiciable action because, of course, there's an entire statute saying this is what you have to do to get off the registry. Judge Wood, you had asked about sort of the consequences of being on the registry in North Carolina if you don't live in the state of North Carolina. And I think candidly, Mr. Frinarelli conceded, well, of course, if he were in North Carolina, he would be subject to all of these things. But I also just note again that there are independent consequences that adhere to being on any state registry, regardless of whether you're in the state in which you are registered. Specifically, there are limitations on international travel. Not only was your passport marked pursuant to Megan's Law, but you have reporting requirements anytime you wanted to travel. You have to notify the sheriff in the county where you reside, wherever that may be, 3 weeks ahead of time, et cetera. So I just note that the consequences to Mr. Goldberg of being on North Carolina's registry exist even if he's not present in the state of North Carolina. And because he's on the registry, whenever he's in the state of North Carolina, for any purpose, all the provisions of the registry apply to him, even if he's not in the state long enough to force re-registration, which I believe would be 14 days. Either if he established residency or if he was present in the state for 14 days, he would be required to re-register. And lastly, Your Honors, I just note there is a venue provision that adheres here, that applies. It's 1-82. I don't think this court need to be particularly concerned about the idea that if it just says follow the venue provisions, we'll sort of see an explosion of people from Nevada suddenly filing in Bertie County because that just seems like a good place for them. There's no real need for this panel to rewrite the statute or do anything other than to say the venue provision allows that in the absence of a legislative mandate, venue is appropriate where the plaintiff files. And then, of course, if the DA in that county felt that that was inappropriate or it would be better heard, then they could simply ask the court to agree with them and have that transferred. In essence, I think all this panel, I would ask this panel, and I would submit that all this panel should do is say this is distinguishable from Dunn. Dunn, there was an issue. The statute plainly applies to all persons. It does not specify exactly where it would be filed. Therefore, the general provisions of venue apply. If for some reason those resulted in a hearing someplace that was inappropriate, then of course the respondent could apply for a change of venue to somewhere is more important. And again, Your Honors, pending any questions, that's really the totality of my argument.
Thank you.
Thank you.
Appreciate it. The case will be submitted. Thank you, counsel, both for your good and professional arguments. And we will adjourn this session of court and then return in ceremonial session in approximately 5 minutes. Thank you both.
All rise. This session of the North Carolina Court of Appeals is now adjourned.
You got the better part of the argument.
It's an uphill climb for you, but